Welcome to our analysis of the sources of presidential power. The presidency that Barack Obama assumed on January 20th, 2009, scarcely resembled George Washington's presidency in the 1790s. From the late 18th century to today, the powers of the president have evolved, reflecting the expansion of the federal government, changes in public attitudes about the proper role of government, and the personalities and the will of those who have served as president. In describing the powers that would guide presidents for centuries to come, the framers of the Constitution created a unique office. These visionary authors had lived through a repressive era in which an authoritarian monarch had exercised absolute power. They subsequently had witnessed the new American nation's struggles under the ineffectual Articles of Confederation, in which the federal government had too little power and the states too much. Thus, the framers sought to establish an office that would balance the exercise of authority with the preservation of the rights and the will of the people. Given their colonial experience, it was no surprise that the framers granted the presidents both expressed powers and inherent powers in the Constitution. Congress grants presidents additional powers called statutory powers through congressional action. We consider these various powers in this Prezi. Additional presidential powers have emerged over time. These new authorities reflect both changes in the institution of the presidency and shifts in popular views on the appropriate role of government and the president. These powers include emergency powers granted in Supreme Court decisions and powers that, though not formalized, are given to presidents by the public through election mandates, presidential popularity, or unified public opinion on a particular issue or course of action. The primary source of presidential power comes from the Constitution in the form of expressed powers, which are those enumerated or listed in the Constitution. Article 2, Sections 2 and 3 list the following powers: serve as Commander-in-Chief of the Armed Forces, appoint heads of the executive departments, ambassadors, Supreme Court justices, people to fill vacancies that occur during the recess of the Senate, and other positions, pardon crimes, except in cases of impeachment, enter into treaties with two-thirds consent of the Senate, give the State of the Union address to Congress, convene the Congress, receive ambassadors of other nations, commission all officers of the United States. The expressed powers outlined in the Constitution provide a framework for presidential responsibilities and an outline of presidential power. They also help shape how presidents themselves develop their authority. One of the principal ways by which the Constitution provided for presidents themselves to assert additional powers beyond those expressed in the Constitution is the Take Care Clause, which states that the executive power shall be vested in a President of the United States of America, and that he shall take care that the laws be faithfully executed. On the basis of that clause, presidents throughout U.S. history have asserted various inherent powers, which are powers that are not expressly granted by the Constitution, but are inferred. President Thomas Jefferson exercised inherent powers in his far-reaching Louisiana Purchase in 1803. Jefferson authorized this $15 million purchase of 800,000 square miles of land, even though the Constitution did not authorize any such action on the part of a president. Interestingly, in the civic discourse over the Constitution, Jefferson, an anti-federalist, had argued for states' rights and against a strong central government and a powerful presidency. Jefferson had believed that the powers enumerated in the Constitution defined the powers of the government. But Jefferson thought that the purchase of the Louisiana Territory was of crucial strategic and economic importance. He believed that the deal was key to the United States averting war with France and to securing the port of New Orleans, which was essential for the American Republic's fortunes in trade. Jefferson could not wait for a constitutional amendment to authorize the transaction, and so he forged ahead with the purchase. Congress and many Americans of the day agreed with his actions, and so there were no negative consequences to them. More recently, in the 1930s, President Franklin D. Roosevelt drew on the inherent powers when he expanded the size of the federal government to administer his New Deal programs, designed to relieve the economic and human distress of the Great Depression. Beginning in 2002, President George W. Bush used the inherent powers when he suspended the civil liberties of foreign nationals being held in military prison at the U.S. Naval Base at Guantanamo Bay, Cuba, as part of the administration's War on Terror. The individuals at Guantanamo Bay have been detained indefinitely for questioning about their possible terrorist activities. These instances of President's exercise of inherent powers generated varying degrees of controversy among Americans of the time. The Constitution's expressed and inherent powers provided a foundation for presidential power that has evolved over time. Those powers have been supplemented by additional powers, statutory powers, explicitly granted to presidents by congressional action. An example of such a grant of statutory powers is the 1996 Line Item Veto Act, which gave the president the power to strike down specific line items on an appropriations, that means spending bill, while allowing the rest of the bill to become law. As noted, in 1997, the Supreme Court declared the line item veto unconstitutional on the grounds that the congressional action violated the separation of powers. Presidents also have special powers that have evolved from various sources, including the Constitution, Supreme Court decisions, and congressional statutes. These powers, which numerous presidents have exercised, have come to be regarded as accepted powers and privileges of the presidency. They include executive orders, emergency powers, and executive privilege. The president has the power to issue executive orders that have the force of law. Executive orders carry the same weight as congressional statutes and have been used in a variety of circumstances to guide the executive branch's administrative functions. In general, executive orders do the following things: direct the enforcement of congressional statutes or Supreme Court rulings, enforce specific provisions of the Constitution, guide the administration of treaties with foreign governments, create or change the regulatory guidelines or practices of an executive department or agency. Executive orders can be an important strategic tool because they convey the president's priorities to the bureaucracy that implements the laws. For example, in 1948, President Harry Truman signed Executive Order 9981, which states, "It is hereby declared to be the policy of the President that there shall be equality of treatment and opportunity for all persons in the armed services without regard to race, color, religion, or national origin." Very controversial at the time. This executive order effectively banned segregation in the U.S. military. Why would Truman issue an executive order instead of working for congressional passage of a statute that would desegregate the military? Many analysts think the reason is that Truman, who ardently believed that the military should be desegregated, not only doubted that Congress would pass such a measure, but also faced pressure from early civil rights activists who had pledged an African American boycott of military service if the military was not desegregated. Executive orders have very few limitations and stipulations. One limitation is that the presidents cannot use them to create new taxes or appropriate funds because the Constitution reserves those powers for Congress. But although there are few limitations on executive orders, an order itself is sometimes not sufficient to ensure that the president's will is followed. Take the case of President Obama. With 2 days into his tenure as president, issued an executive order declaring the detention facilities at Guantanamo Naval Base in Cuba be closed by January 2010. Because of the complexity of the Guantanamo situation, they need to determine the status of all prisoners and relocate them. The detention center is still open. Emergency powers. Broad powers that a president exercises during the time of national crisis have been invoked by presidents since Abraham Lincoln's claim to emergency powers during the Civil War. Lincoln used emergency powers during the war to suspend the civil liberties of alleged agitators, to draft state militia units into national service, and to federalize the governance of southern states after the war. In 1936, the U.S. Supreme Court acknowledged the existence of presidential emergency powers in U.S. versus Curtiss-Wright Export Corporation. In this case, the U.S. government charged the Curtiss-Wright Corporation with conspiring to sell 15 machine guns to Bolivia, in violation of a joint resolution of Congress and a presidential proclamation. Without congressional approval, President Franklin D. Roosevelt had ordered an embargo on the machine gun shipment. The court supported FDR's order, ruling that the president's powers, particularly in foreign affairs, are not limited to those powers expressly stated in the Constitution. The justices also stated that the federal government is the primary actor in foreign affairs, and that the president, in particular, has inherent powers related to his constitutional duties in foreign relations. Presidents can also exercise executive privilege, the authority of the president and other executive officials to refuse to disclose information concerning confidential conversations or national security to Congress or the courts. In invoking executive privilege, presidents draw on the idea that the Constitution's framework of separation of powers justifies the withholding of certain information from Congress or the judiciary. A claim initially asserted when George Washington refused to grant Congress access to all documents pertaining to treaty negotiations. Typically, presidents claim executive privilege so they can get advice from the aides without fear that such conversations might be made public or scrutinized by members of Congress or the judiciary. Presidents also have invoked executive privilege when negotiating foreign policy with other heads of state, to shield these leaders from having sensitive negotiations examined by the other branches of the federal government. On occasion, the judicial branch of the federal government has successfully challenged executive privilege. For example, when President Richard Nixon refused to turn over tapes of Oval Office conversations to a special prosecutor investigating the Watergate scandal in 1974, the Supreme Court intervened. I forgot to put this case in the Prezi, so make sure you write this down. In U.S. v. Richard M. Nixon, or U.S. v. Nixon, the court asserted that although executive privilege does exist, it was not applicable regarding the tapes because President Nixon's claim of executive privilege concerning the tapes was too broad. More recent cases in which a president has invoked executive privilege are notable. President Bill Clinton attempted to do so to prevent White House aides from testifying before Special Prosecutor Kenneth Starr during the Monica Lewinsky scandal. Clinton was accused of having extramarital relations with Lewinsky, a White House intern. Clinton's maneuver failed, and his aides were compelled to testify. In 2007, President George W. Bush's asserted executive authority in a showdown with Congress over the politically motivated firing of 9 U.S. attorneys. Make sure that you're writing the example of Bill Clinton and George W. Bush down. Bush invoked executive privilege to prevent White House counsel Harriet Miers and presidential advisor Karl Rove from testifying before Congress. The congressional inquiry continued without Miers and Rove's testimony, however, and eventually Attorney General Alberto Gonzales stepped down as a result of the scandal. In general, the courts have allowed executive privilege in cases where a clear issue of separation of powers exists, as with respect to international negotiations and conversations regarding matters of policy or national security. The courts have tended to limit the use of executive privilege when presidents have exercised it in an effort to prevent the revelation of misdeeds by members of the executive branch. That's an important distinction. Make sure you write that down.